First of all, a very Merry Christmas from all of us at Jones Chase. Thank you for joining our webinar today, which is great, and a very good afternoon as well. And so this is the next Your Employment webinar in the series, providing you with essential employment law and HR updates. For those of you that are new to our webinars, we are, of course, Jones Chase, a firm of specialist employment lawyers, and we act for a number of companies from PLCs all the way through to startups, and also some fantastic individuals as well. We also have a very high success rate for looking after those that we represent, and we're delighted to have you with us. So just before we have a quick introduction, we've got surprise guest speaker today, Zainab, who wasn't mentioned on any of the invite notes. But anyway, so just to introduce the team who's going to be speaking today, we've got one of the firm's partners, Shona.
Hello, good afternoon.
Zainab is obviously one of our associates.
Hello.
And Jessica, one of the firm's paralegals.
Hi, everyone.
And Dominic, the other paralegal in the firm.
Hi, good afternoon.
Okay, thanks, guys. Okay, just moving on in terms of the format for the webinar. If you want to ask us any questions, please use the Q&A box. If you want to do that anonymously, hit the anonymous button as well. We will be recording the webinar to pass this on to people that couldn't make it today. So yeah, definitely use the anonymous button if you want to ask things anonymously. If you want to speak live, write that into the Q&A chat, and myself or one of the team will unmute you. And I must emphasize the points we're covering today are not formal legal advice, and so much depends on the facts of any particular case. Sometimes the approach that you take in one case is not the one that you take in another. So please don't rely upon this webinar for formal legal advice, and definitely drop us a line instead. As a quick reminder, the information we're covering today is accurate as of 4 o'clock on the 15th of December 2022. Things always change quickly in employment law, so do drop us a line if you have any further questions. And everyone's time is precious, so we'll be definitely finishing at 5 o'clock today, the latest, if not before. Lastly, we do like helping people. So if there's any businesses or individuals that that you think would work well with us or that we can help, definitely ask them to drop us a line. All of our information is on our website, www.joneschase.com. So moving very quickly on with the content. So we are going to do a Christmas quiz at the end of the webinar with 5 questions with prizes, and we'll come on to that. In the meantime, I'm just going to hand over to the team, and Zainab first, who is going to run through the key employment law developments in 2022. So over to you, Zainab.
Thank you very much, Dean. So we are going to do the 12 months of Christmas today. I'm starting with January 2022. So I don't know if you feel the same way, but for me, that feels like it was decades ago. And unfortunately, I'm going to be starting with something you might have hoped to have forgotten forever, but I'm going to take you back to COVID-19. So the government began lifting of Plan B, which was implemented following the spread of Omicron. And on the 19th of January, 2022, we had a statement from our ex-Prime Minister, Boris Johnson, lifting working from home guidelines. And then on the 27th of January, because of the successful booster rollout, all measures under Plan B were lifted. So that meant that face coverings were no longer mandatory in indoor venues. I'm going to pass over to Shona for February.
Hello. So in February of 2022, the main case that month involved Tesco's. We've just got over COVID. We've had a long period of instability within the workforce. And in February, well, it's actually in January that the decision's made, but the impact is felt in February. Tesco's decided it was going to remove retained pay from certain of its warehouse staff. Retained pay was something that Tesco's had introduced in 2007. In 2007, it was deciding to move its warehouses from a place called Crick to 2 different places, one called Lichfield and one called Daventry. And Tesco's really wanted its warehouse employees to move with it. So to move from Crick to Lichfield and or Daventry. And so in order to incentivize the warehouse people to move with it, it offered a salary that was already being paid. And on top of that, an extra retained pay that it said would also be added to pensions, holidays, sick pay, and a weekly extra wage that all warehouse staff would get. If you didn't sign up to this, fine, it would then mean you were redundant from your job in Crick. But if you signed up, your contract of employment going forward would include this retained pay element. So this is 2007 when Tesco's offered this. Fast forward to January of 2022, and Tesco's is deciding actually, but we don't want to pay this anymore. We want to take it out of the contracts of employment of those employees who still have it. And so they decided in February to offer those employees 18 months worth of retained pay, but then to offer new contracts for old. And this is this fire and rehire notion. We'll fire you on this contract, which includes the retained pay, and we'll take you back on this contract, which doesn't include it. But in order to give you something for the taking away of a contract and introducing of a new contract, we're going to give you 18 months worth of this retained pay. 43 of the employees said, well, hold on a minute, I want to keep my retained pay and I want to keep my job. And so along with their union, they applied for an injunction to stop Tesco's giving them notice to end their current contract with the retained pay in it. And the judge in the High Court gave the employees and the union that injunction. So they imposed an injunction against Tesco's to stop Tesco's from ending the old contract and putting in a new contract in place without the retained pay. So this is February of 2022. You'll remember we move into March when the injunction was granted. March is the month when P&O Ferries did a fire and rehire for 800 of its staff and said, we don't want you on this salary anymore. In fact, we've got agency workers that we can take on a much lower salary, that much lower salary being less than the minimum wage. But because P&O Ferries were arguing they're not subject to the jurisdiction of the UK for that minimum wage, they thought that they would be able to take on those agency workers for that lower pay. The P&O Ferries employees in that situation weren't being offered something in the alternative. They were just being told you're fired, and that was without 90 days consultation because 800 employees were involved, and also could have made unfair dismissal claims for those with over 2 years service. P&O Ferries offered everyone a settlement in that, and many P&O employees signed those settlements, but Tesco's had an injunction against it at the same time. You cannot end the contracts of employment of those employees on retained pay. But this story is not finished. We will come back onto it later in the year. So I'm going to pass over to Jessica. We've got through February and March. Jessica, what happened in April?
Thank you very much, Shona. So in April, April brought us to employment tribunal decisions on worker status, which we're continuously seeing in the tribunal. The first is Lutz and Ryanair, DAC and others. In this case, Mr. Lutz applied to be a pilot for Ryanair, was successful and was then passed to MCG, which managed Ryanair's pool of contracted pilots who work alongside their employed pilots. MCG organised the setting up of a service company so that Mr. Lutz could operate as a self-employed pilot. MCG entered into a 5-year fixed-term contract with the service company under which all work was exclusively for Ryanair, and Mr. Lutz was on an agreed, acceptable and qualified nominated substitute who would perform the work. Or an agreed, acceptable and qualified nominated substitute who would perform the work. The tribunal held that Mr. Lutz was not a self-employed pilot with Ryanair as a customer of his service company. He was never a shareholder, director or employee of the service company into which MCG had installed him, and Ryanair had no dealings with the service company. Nor was he an employee of Ryanair, as there was no contract of employment between them. Since he was not in business on his own account and MCG were the intermediary through which Ryanair dealt with its contracted pilots, the tribunal concluded that MCG supplied Mr. Lutz to Ryanair as an agency worker. To be an agency worker, the work must be temporary. And the tribunal held that the 5-year fixed-term contract between the service company and MCG was not indefinite and was therefore temporary. In deciding that Mr. Lutz was an agency worker, the tribunal found that he had a contract with MCG to supply services personally and not through the service company. The tribunal's view was that his ability to swap shifts was not substitution, but a rearrangement of the day and time when personal service was required. In any event, there was no unfettered right of substitution. Only other Ryanair pilots could take the shift and permission from Ryanair was required. The contractual documentation purporting to show that it was not a contract for personal service was a sham. Every aspect of the engagement was structured as Ryanair dictated, and Mr. Lutz's independence was entirely notional, with Ryanair rostering his flights and requiring him to wear their uniform. On the other hand, also in April, in the case of Baker and others and the Post Office, the Employment Tribunal found that a group of 120 postmasters were not workers under the working time regulations because there was no requirement for them to provide services personally. Moving on to May, we have a really interesting case about expressing milk and harassment in the workplace. In the case of Mella and MFG Academies Trust, the Employment Tribunal delivered a judgment holding that a woman suffered harassment related to sex when her employer failed to provide a private room for her to express breast milk at work. As a result, the employee had to express in her car or in the toilets, and the tribunal found that this had the effect of creating an unwanted or humiliating environment for her. However, the tribunal's dismissal of the accompanying claims for direct and indirect sex discrimination really highlights the lack of legal protection for breastfeeding employees in the workplace. I will now hand over to Dom, who has an interesting case in June.
Thank you, Jessica. So for June, I'll be covering the case of McClung and Dewson Babcock Limited. And in this interesting case, there was a preliminary hearing held on the 1st of June 2022 to determine whether support for Glasgow Rangers Football Club, otherwise known as Rangers, is a philosophical belief in terms of Section 10 of the Equality Act. So the claimant had been a supporter of Rangers for 42 years. He had supported them since he was 8, is a member of a charitable foundation connected to the club, and he also spends most of his disposable income on attending games, as well as various other factors considered by the tribunal. So the claimant worked as a subcontractor for the respondent and claimed a manager denied him further work because she was a Celtic fan, who were of course rivals to Rangers. As a result, he brought claims for unfair dismissal and discrimination. The judge submitted that a belief in the support of Rangers did not meet the necessary requirements for it to be categorised as a philosophical belief. As a reminder, the 5 requirements were: firstly, the belief must be genuinely held. Secondly, it must be a belief and not an opinion or viewpoint based on the present state of information available. Thirdly, it must be a belief as to a weighty and substantial aspect of human life and behaviour. Fourthly, it must attain a certain level of cogency, seriousness, cohesion, and importance. And finally, it must be worthy of respect in a democratic society, be not incompatible with human dignity, and not conflict with fundamental rights of others. So the judge held that the claimant only met the first requirement, that the belief was genuinely held, and therefore could not qualify as a philosophical belief, which amounts to a protected characteristic under the Equality Act. The judge in particular submitted that support for Rangers was support and not a belief, and therefore did not meet the requirements of point 2. Support in this context may be defined as being actively interested in and concerned for the success of a particular sports team, for example. And belief may be defined as an acceptance that something exists or is true, especially one without proof, or something one accepts as true or real and is a firmly held opinion. The two it was submitted were not the same thing. An interesting point for this case was that Celtic and Rangers rivalry is built upon division due to religion. Traditionally, Rangers supporters are Protestant, while Celtic fans support the Catholic Church. The judge did recognise this in her submissions, but stated a religious belief was not a prerequisite to supporting Rangers. So I'm now passing over to Zainab, who will be speaking about another case on belief for July.
Before we go on to that, actually, Zainab, something. So I'm going to go with this football thing. I hear the Rangers thing, but I think if you said that you had a philosophical belief in relation to football, and so it was much broader than just Rangers, and it was you lived your life by football, etc. You genuinely believed it. It's weighty and substantial. It certainly is something that's worthy of respect within the world. Look at the World Cup now. There might have been a chance that the individual, I know that there's this cogency, still think it's a cogent thing to have a belief in football. There is still a chance that possibly they could get over that threshold of belief, that maybe it was just linking it to Rangers. I'm not casting any aspersions on Rangers, but just linking it to a particular club, and it would be football, like veganism. What do you reckon?
Yeah, and veganism and vegetarianism was actually mentioned during this case in the judgment. So there's potential for that to be classed. I think it's quite difficult because I'm not too knowledgeable on kind of European football, but in British football, Rangers and Celtic's rivalry is probably the most, I don't know, maybe bitter's maybe the wrong word, but there's the biggest rivalry between those two. And because it is linked to religion, then that was what was most surprising about this case. But yeah, potentially if it's just football, whether that could get over that kind of the hurdle of it being an opinion or viewpoint, maybe the difficult part.
Well, I think you've raised a good example. So the vegetarianism is not a belief. Veganism is a belief in, and that's the distinction. So maybe football falls more within vegetarianism than it does veganism.
Yeah,
but I think that it's almost the wider you go in terms of belief, maybe the easier it is. Interesting case.
Thanks. Just by the way, just to jump in, so I'm not sure if this is intentional. Rosie's raised the hand. So Rosie, if you'd like to say something, just drop it in the Q&A box. If you want to be unmuted, we can unmute you as well. If you've done it accidentally, as some people do, don't worry. But yeah, if you drop anything you want to say in the Q&A box, we'll take it from there. Okay.
Maybe Rosie supports either Liverpool or Everton, Liverpool or Everton, or Celtic, or could possibly one of the Manchester City or United, and talks about rivalry. My goodness, you know, I'm going to tell you some more rivalry.
Okay, so Rosie's mentioning here, what about point 5?
So that's it must be worthy of respect in a democratic society, not incompatible with human dignity and not conflict with fundamental rights of others. So
to me, that should be a tick point for football. It is certainly worthy of respect in common society. I think we refer to that in terms of just looking at the World Cup at the moment and how much it's raised all the issues for and against other types of protected characteristic, but for me, football is worthy of respect.
That's great. Okay, thanks for that, Sharon and Dom. And yeah, Rosie, if there's anything else or anyone else would like to say something, just drop in the Q&A box. We'll take it from there. Okay, so I'll obviously hand back to the team for whoever's going next.
It's me. Thanks, Dean. I'm actually going to carry on this discussion on philosophical belief with another case from July this year, which is the Forstater and CGD case. So this is a case in which it was held where Mrs. Forstater held or holds rather gender critical beliefs, which include the belief that sex is immutable and not to be conflated with gender identity. So she engaged in debates on social media about gender identity and issues related to the same, and would make remarks which some transgender people found offensive or transphobic. Some of her colleagues complained about the comments that she was making, and following an investigation, her visiting fellowship wasn't renewed. She complained that she was discriminated against because of her philosophical belief. There was a preliminary hearing to determine whether her belief was a philosophical belief within the Equality Act. The tribunal found that the belief, being absolutist in nature, and whereby the claimant would refer to a person by the sex, sorry, this is a quote, would refer to a person by the sex she considers appropriate, even if it violates their dignity and or creates an intimidating, hostile, degrading or offensive environment. The fifth requirement for philosophical belief was therefore one that was not worthy of respect in a democratic society. However, this went to appeal and it was held and the appeal was allowed. The tribunal had made a mistake. The philosophical belief would only be excluded for failing to satisfy criteria if it was the kind of belief of expression which would be akin to Nazism or totalitarianism. So you can see how high the threshold is there that the appeal tribunal put on this, and thereby liable to be excluded from the protection of rights under the convention. So her beliefs, which were widely shared, did not seek to destroy the rights of trans persons, didn't fall within that category. Her belief, whilst offensive to some, and notwithstanding its potential to result in harassment of a trans person, still fell within the protection of the convention, and also then within the Equality Act as well. The tribunal made it very clear at this stage that the judgment didn't mean that they were expressing a view on the merits of the transgender debate. They also said that, you know, it didn't mean that those with gender critical beliefs can misgender trans persons. They didn't mean that trans people wouldn't be protected under the Equality Act, or that employers would not be able to provide a safe space for their trans people as well. I'm going to move over to Jess, who's going to continue with July. It was a big month.
Actually, just before we go on to that, Zainab, because the reason that case was heard in July of 2022 was to allocate compensation to the claimant.
Yeah, for the discrimination claim.
Yeah, for the discrimination. And one of the things they also mentioned was the salary, because she had carried on working, and they couldn't determine that any reduction in salary was affiliated with the claim that was being made and or the assertion being made. So they did, as you say, rely upon the injury to feelings, which is why we're covering it this year, because people may think, oh, they decided that last year.
Lovely, thank you, Shona, and thank you, Zainab. So we're sticking with July, and this time we're talking about whistleblowing in the case of Kong and Gulf International Bank. Now, this case was heard in July in the Court of Appeal, so there's a couple of appeals to kind of go through to give you some context of the case. Ms. Kong worked as head of financial audit at Gulf International Bank. She made a verbal protected disclosure to Jenny Harding, head of legal, to the effect that essentially an industry standard financial compliance template that was designed for bank-to-bank lending was not suitable for the use the bank was making of it for non-bank-to-bank lending. Ms. Kong also sent Ms. Harding an email the next day repeating what she had said to her the day before. Ms. Harding was upset about what had happened, both in their meeting and in the content of the email, and said that she could no longer work with Ms. Kong. Subsequently, Ms. Kong was summarily dismissed by 3 senior individuals at the bank about a month and a half later. She brought claims for ordinary unfair dismissal, automatic unfair dismissal by reason of protected disclosure, detrimental treatment by reason of having made a protected disclosure, and wrongful dismissal. She actually relied on 10 protected disclosures. The Employment Tribunal held that Ms. Kong was unfairly dismissed, but rejected her protected disclosure, detriment and dismissal claim, along with her wrongful dismissal claim. In relation to the protected disclosure detriment, the Employment Tribunal found that Ms. Harding, who was upset by the protected disclosure about the template and because her competency was questioned, had subjected Ms. Kong to a detriment materially influenced by the protected disclosure. However, this claim was out of time. In relation to the protected disclosure dismissal, the Employment Tribunal found that the reason for the dismissal was not the protected disclosure itself, but it was that she had questioned Ms. Harding's professional awareness or competence. The Tribunal asserted that this was a separate reason related to her conduct and not her protected disclosure. It is this separability ground in relation to the protected disclosure dismissal that Ms. Kong challenged and which brought the case to the Employment Appeal Tribunal. Now, the Employment Appeal Tribunal upheld the Tribunal's original decision. Having considered the case of Royal Mail and Jehuti, it agreed that it was right not to attribute Ms. Harding's motives to the bank, and the focus should be on the motives of the dismissal decision makers only, in this case, the 3 senior individuals. Ms. Kong argued that dismissing her for questioning Ms. Harding was, in effect, dismissing her because of the whistleblowing disclosures, as the 2 were inseparable. The EAT disagreed. It stated that Ms. Kong's concern about the bank was in danger of breaching regulatory requirements by using a legal agreement which was unsuitable for a new financial product, that was separable from how the state of affairs had come about, and who was responsible for it and whether they deserved criticism in that regard. At this stage, the whistleblowing charity Protect intervened, and the case was appealed to the Court of Appeal, where it was heard in July this year. So Protect argued that an employee's conduct in making a disclosure should only be properly considered separable from the making of a protected disclosure where the conduct constitutes wholly unreasonable behaviour or serious misconduct. The Court of Appeal did not agree. It stated that in principle, there can be a distinction between the whistleblowing disclosure itself and the conduct associated with making the disclosure, this separability principle. The role of the tribunal is to identify the reason or reasons that operate on the minds of the decision maker when deciding to dismiss. Tribunals should be able to identify a feature of the conduct relied upon by the decision maker that is genuinely separable from the whistleblowing disclosure. Provided that they can do this, the principal reason for the dismissal will be conduct, not the whistleblowing disclosure. So essentially, the question is what motivated the decision maker to dismiss or treat a whistleblower in an adverse way. Here, the tribunal was entitled to conclude that what motivated the decision to dismiss was not Ms. Kong's protected disclosure, but rather her lack of emotional intelligence and insensitivity in the way she conveyed personal criticisms of her colleague. Now, I've done quite a bit of reading around this case, and there is suggestions that Ms. Kong will appeal to the Supreme Court, but I couldn't find anything to suggest that that was a firm happening. But I will, sticking to July, I will now hand over to Shona.
Yeah, we're still in July. Actually, yesterday, Protect, the legal director at Protect, issued a report on the direction of travel of whistleblowing cases, saying it looks as if they're more difficult to succeed in such a case if you're a claimant. And yeah, it's worth reading that report. It's on the Protect website. So we're in July, we're back in Tesco's, and Tesco's naturally appealed the injunction that had been awarded against it in February. So this was an injunction to stop the notice period on the contracts of employment of those employees with retained pay, to take away that retained pay. An injunction is a legal remedy where the people seeking the injunction are saying, money's not enough here, you've got to stop somebody doing something, and that's why they got the injunction in the first place in February. We're in July, Tesco's have appealed this, and the courts in July agree with Tesco's this time, and they say, yes, Tesco's, you are correct. There should not be an injunction against you. Every employer has the right to serve contractual notice on an employee to end the current contract of employment and to start a new contract of employment at the end of that notice period with the current contract of employment. The two clauses that Tesco's were relying upon, the retained payment clause says, under the arrangement for moving to the new Lichfield site, you're eligible to receive the sum of £134.70 per week as a retained payment. This payment is part of your contractual terms and conditions, as is included in your calculation for pensions, benefits, shares, and your retained payment will be uplifted in any future pay negotiations. The retained payment can only be altered in agreement with yourself and ceases where you agree to a promotion or where you request a fundamental shift change, for example, a move from day to nights or a move from nights to days, when there will be an adjustment to the premium payment only. In the event of a company-initiated change, there will be no reduction in your retained payment. So if you were reading that as an employee, you would think that was a pretty solid £134.70 that you were going to get every month for the retained payment. But there, in that contract of employment, there was a notice clause that gave the company the right to give notice to terminate the contract and setting out a schedule of period of notice that was in line with Section 86 of the Employment Rights Act. So ultimately, in July, the courts have said every employer has the right to end a contract of employment based upon that notice clause, and that an injunction is not the correct remedy. Now, Zainab, we're on to August. What happened in August?
Should unmute myself. So August, yes, we had a case on an anonymity order. It was the case of Pipenbrook and LSE, so the London School of Economics. So the tribunal has the ability to make anonymity orders, or what referred to as restricted reporting orders, where it considers that in the interest of justice, it needs to protect someone's convention rights in relation to confidential information. So the types of order that a tribunal could make could include protecting the identities of specific parties or of witnesses. Before making this order, a tribunal has to give full weight to the principle of open justice and the right of freedom of expression as well under the convention. So the EAT has much more limited powers in respect of anonymity orders, but one of the powers they do have is to grant one in cases involving allegations of sexual misconduct. And this case did that, and it was in an appeal tribunal case. So Dr. Pipenbrook was a fellow at the LSE. He was in the US delivering lectures in 2012, and he was accompanied at that time by a much younger female colleague referred to in the tribunal proceedings as Miss D. Miss D made a complaint of sexual harassment against Dr. Pipenbrook. He subsequently alleged that she had made sexual advances towards him, that she was stalking him, that she had exposed herself to him. He went on sick leave with anxiety and depression for 20 months, and then his fixed-term contract was not renewed at the end of 2014. He then brought claims in the Employment Tribunal for unfair dismissal, victimization, discrimination arising from disability, as well as some High Court claims too. He made an amendment to an application to amend the tribunal to add new claims. That was refused. He then appealed to the EAT and lodged various documents, some of which contained the allegations against Miss D, including some in which she was named. The EAT dismissed his appeal in a judgment, but decided that LSE's application for the order to prevent disclosure of Miss D's identity would be heard separately. She was not a witness, she wasn't a party to the claim, and she wasn't going to be providing any evidence, but she had given some evidence on behalf of the LSE during the tribunal proceedings. So an interim order at that stage was made to preserve her identity. Before the EAT heard the application, the tribunal actually dismissed all of Dr. Pipenbrook's substantive claims against LSE. In its judgment, they concluded essentially that he wasn't a credible witness, and honestly that he was just quite a horrible man by the reading of the judgment. He was frequently malicious and actively destructive towards people that he felt had wronged him. So on that basis, his claims didn't continue, but the tribunal specifically found that the allegations against Miss D were untrue and that he had made them maliciously, and she was anonymized throughout the tribunal's judgment on that matter. So we are still in August, and I'm handing over to Dom.
Thank you, Zainab. So yeah, still in August, another case that I'll be looking at is hrmanagers. And this judgment was given on the 18th of August 2022, and it was a Supreme Court decision. So it was held that employees who lie on their CV can be prosecuted and ordered to pay back proportionate earnings. So as background in this case, it was a CEO who lied on his application form about both his qualifications and management experience. He was then imprisoned and ordered to pay back his full net earnings, despite performing well in the role for 11 years. He was prosecuted in 2017 and went to jail for 2 years, but appealed the decision. So at the Supreme Court, it was decided that it would be disproportionate to make an order for repayment of his full net earnings, as the value of services he provided in the 11 years as CEO should not be ignored, and he did perform well in the role. On the proportionality point, it is the difference between the high earnings actually obtained and lower earnings that would have been obtained had the individual not lied. So the principle being that the individual should repay any what's known as profit made from his lies, but with the account taken of the services rendered during the 11 years of his service. So this case acted as a reminder to employees of the serious consequences of lying on a CV or job application. And the Supreme Court also noted the distinction between this case and cases where performance in the role is illegal without the necessary qualifications or license. So for example, a medical professional. And it noted that in such cases as that, it would not be disproportionate to order repayment of the full net earnings. So now passing on to Shona for September.
Yeah, and September was the month when the Queen died, and so the employment law aspects of that related to holiday. The King, King Charles, was allowed and is allowed as King to declare a bank holiday, and he did so in relation to the 19th of September, which was the Queen's funeral. And I just thought it was worth then checking how these bank holidays came about, because, when can King Charles announce that there's another bank holiday? And the authority is this, that there are currently 8 bank holidays in England. There are 10 in Northern Ireland. There are 9 in Scotland. There are 8 in Wales. And of those bank holidays, King Charles can actually say that they can be taken on different dates. So there could come a point at its ultimate extreme where we've got 4 bank holidays being taken in a row, if King Charles thought that was a good thing to do. There is guidance that he ought to confer with ministers, because there might be a business response to declaring all bank holidays change dates, but it is all within his gift to allocate the date. For an extra day, again, the King can allocate an extra day, but again, the guidance is that he has to do that with ministers. So yeah, I didn't realise that the King had so much power and the Queen before him. Just as a reminder with holidays, there are 5.6 weeks holidays for a full-time employee under the working time regulations. Those 5.6 weeks, there's no specific date that an employee has to take those 5.6 weeks, or the employer has to allow the employee to take. So if your contract refers to 5.6 weeks, and you want to suggest that the employee does not want to work bank holidays, you can so in the contract of employment, as there is no legal right to have a bank holiday off or a public holiday. That was a little fun fact that came out of this. I'm going to pass you on to October.
So that's me, and I'm going to be talking to you about a reform that came in it was announced as part of former Chancellor Kwasi Kwarteng's mini budget on the 23rd of September. But on the 17th of October 2022, IR35 responsibility is going to remain with employers going forward, which is a bit of a U-turn by the government. So the mini budget had an announcement whereby employers would stop being responsible for deciding whether the IR35 tax rules would apply to contractors working for them through personal service companies. And on the 17th of October, Jeremy Hunt announced the proposed changes would not take place. So we've gone forward, backwards, upside down, all the way around with that. The change would have effectively removed reforms introduced in 2017 and 2021, when responsibility for checking whether IR35 applied passed from contractors to their public and private sector employers. So on to, who are we on to? We're on to November.
Yeah, thank you, Zainab. So in November, it wasn't a case that I'm covering, but there was the announcement that there would be pay increases for statutory benefits, which are to take effect from April 2023. So the Department for Work and Pensions published its proposed increases to several statutory benefit payments, which represent an increase of 10.1% on the rates applicable for 2022-2023. And the rates will apply from the 10th of April 2023. And if you would like these exact figures, we would be more than happy to provide them following the webinar, and the same goes for any cases we've mentioned if you would like the full details of those cases. So passing on to December now, which I believe is Dean.
Okay, that's great. And sorry, just losing my voice a little bit. Just a very quick update for December, because we're halfway through. Just to announce that there's obviously been unprecedented strike action this month, and the government have announced they are going to be looking into this. Nothing's happened as of yet, although I believe there's been some COBRA meetings, or will be COBRA meetings, because the sheer volume of strikes has taken them, taking the country by storm and taking the government by surprise a little bit as well, perhaps. But so the government are looking into it. There'll be more on this in 2023, and we'll obviously keep you updated in that regard. Just a quick thank you for the team, for doing that wonderful month-by-month update for 2022. We have a Christmas quiz to come, but we're going to stop the recording in a moment. So for all those watching online, particularly for all those attending the webinar live, please stay on for the Christmas quiz. For all those attending online, just a quick reminder that we are Jones Chase Employment Lawyers. Thank you so much for supporting the webinar project and working with the firm this year. It's been great to being here to help you. And yeah, we massively appreciate our fantastic client relationships. And the information we're covering today is accurate as the 15th of December 2022. And yeah, for those online, we wish you all the very best, and Merry Christmas and a Happy New Year. So we're going to stop recording now for all the live guests, and please do stay on and we'll do the Christmas quiz. Okay, so thank you very much, and Merry Christmas, Happy New Year.